Court is back in session and calls number 330-990. The case is styled the state of Texas versus Christopher Howell Brosh. Mr. Brosh, I have before me a document that is titled Judge's Explanation of Defendants Without Attorney. Mr. Brosh, you recognize this document?
Yes, sir, I do.
And is this your signature on the line entitled defendant?
Correct, it is.
And are these your initials on the line stating that I want to apply for court-appointed attorney?
Yes, sir.
And I have another document before me that's titled Affidavit of Indigence. Mr. Brosh, do you recognize this document?
I do, Your Honor.
On page 2 of this document, there's a signature above the line that is titled defendant. Did you place your signature on this document?
I do, Your Honor.
Now, Mr. Brosh, prior to signing and initialing all of these documents that I've just read, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
And Mr. Brosh, I've read your affidavit of indigence, and based upon your answers, you meet the eligibility requirements for the appointment of court-appointed attorney. And your attorney that will be appointed to represent you in this case is Attorney Don Boudreaux. Okay? Our court coordinator is going to give that information on Mr. Boudreaux, and Mr. Boudreaux will be given information on how to contact you as well.
Yes, sir.
Now, Mr. Brosh, in reference to your bond, let's do this here. I need to get some, now have,
Judge,
yes,
can I interject real quick? On him, as he has not made on Thursday, what do you want to do?
I mean, his attorney, we have to contact his attorney, see what his attorney wants to do. If his attorney wanted to be set for Thursday or reset. It's gonna be up to his attorney, Mr. Boudreaux.
Judge, can I say something? Is it okay?
Okay, now, I can't give you any legal advice, and if you, anything that you say can and will be used against you in a court of law, so you have a right against self-incrimination, and you have already been appointed an attorney, and your attorney is Mr. Don Boudreaux.
That you were talking about the bond on the other issue.
Oh, yeah, I hadn't said it, yeah, I didn't get some, I was
Yes, sir.
in the process of getting
I
some
apologize.
information
I
from him.
apologize for interrupting.
Now, he has an outstanding bond, correct? He has another,
Yes, in that case, I'm gonna have to give him a court date if you're gonna with the attorney.
okay, but give us, what is the bond amount in that case?
He didn't have.
And he doesn't have, I'm not talking about the new case. I'm talking about the case that he's out on bond on. Because he's out on bond on one case, is that correct? It's a PR bond. No.
That's okay.
No, Bail America is your bondsman on that one, right?
Yes, sir.
What is your bond on that? It's set at 500?
Yes, sir. Yes, Your Honor.
Is that the only case that you have a current outstanding bond on?
Oh, yes, sir.
Okay. Wait up. Why do I see Bail America on both of these cases? I see that. You got bonds on both of these
I'm
cases.
confused. I'm confused.
Yeah, I know. You
I
said,
thought this was already taken care of.
I have no idea unless it's a AFRS.
You can show a bond at 331-214.
We're gonna look into it. I just saw that. It says Bail America on both of them.
Yeah, I thought it was.
Hold on a minute. this is what we're gonna do. We need to, what's his history? Yeah, any other cases? Could I get a printout of that? Oh, yeah, give me a
All of
printout.
these procedures will take place.
Yeah, give me a printout.
I'll print it out.
Okay. Okay. Let me do this here. Gonna go off the record. And that's pursuant to 1.24 Texas Code of Criminal Procedure. And that statute states that all proceedings and trials should be open to the public. Shall be public, yeah, all proceedings and trials in all courts shall be public. However, pursuant to Lilly versus State Southwest, Lilly versus State 365 Southwest 3rd 321. The right to a public trial is not absolute and may be outweighed by other competing rights or interests such as interest in security, preventing disclosure of non-public information, or ensuring that the defendant receives a fair trial. And now, Mr. Brosh, you have a right to have a public trial. Now, the court is just trying to get some information to set your bond. And based on the questions that I'm going to ask will be involving criminal histories and stuff like that. And so that information is normally confidential, non-public. If you do not want that, because we are currently on YouTube, if you do not want that to be broadcast or to prevent the disclosure of that non-public information, then the court can close the hearing to the public. Do you understand what I'm saying? Now, do you want the hearing to be closed to the public?
Yes.
Okay. Okay, at this time, the court finds that the party seeking to close the hearing have advanced an overriding interest that is likely to prejudice them because it will disclose non-public information, and this closure is no broader than necessary to meet that interest. And the court have considered reasonable alternative to closing the proceeding, and the court make the findings that this court is making is adequate to support the closure. And so at this time, this